Hello, welcome back to Paralegal Counseling Training. We are looking at court process and litigation, and we looked at how the litigation is done in the criminal jurisdiction. We said that in the criminal jurisdiction, it starts from the arrest of the suspect, and the suspect is brought before court. Then the prosecution, who are the players in the criminal jurisdiction, we said that there must be the accused, there must be the prosecution, there must be the jury, who is the judge, and also there can be a lawyer for the accused. Now, we talked about how the case is brought in court, and now the prosecution now have started bringing in the witnesses, and they are bringing in the evidence before court to prove that the accused committed a crime. Now, in doing that, we said that the prosecution must prove to the court, must bring the evidence to the court. Number one, by bringing the witnesses or who are state witnesses who should be able to witness against the accused. And the first witness that they are supposed to bring, it is the complainant. That is the first witness, and then they have to bring the corroborating witnesses to attest or to testify about the action that the accused had done, which they saw or they witnessed. Then after that has happened, there must be now the arresting officer, who should be able to conclude the case by by summarizing what the witnesses said and how what happened, how it took the process up to the time he arrested the accused, and how he finally saw that it was necessary for this accused to be brought before court, and he has to bring in the exhibits or the exhibits before court, and the evidence before court, telling the court that concluding that this accused had committed a crime. So that is the first stage in the court jurisdiction of the criminal offense. Now, the first stage, that is where now the court is going to determine, which is the jury is going to determine whether the case should be continued or the case should be washed out. There is what is called prima facie, whereby now the court must, the prosecution must establish the prima facie, which means the evidence now has to agree that the evidence must show that and convince the court that the accused may have committed a crime. And that is what is in the first part of the case. Now, today I want us to look at the other thing now that happens. So we are going to look at what is called cross-examination. And in the cross-examination, we are going to look at how to examine the witnesses and how to examine the police officer, who is the arresting officer in court. So that is what we are going to look at, because the first part of the case, the first part of the court session, which is the trial, and where the prosecution must establish the case and must be able to convince the court that really a crime had happened by bringing in the evidence through the witnesses and also the exhibits that they should bring before court. So that is the first stage. And as I said, at this stage, the jury or the judge now is going to make a ruling whether the case should continue into defense or the case should be squashed off, which is normally called washout. So now, if the case is squashed off from that, then the accused, does not need to bring the witnesses and does not need to answer or to testify. Now, we are going to direct now today's class on the cross-examination. As I said, we as the paralegal counselors, our main duty is to help this client or this accused to be able to examine the witnesses. And mostly in Zambia, we don't have the accused, mostly they stand in court without the lawyers because of the exorbitant charges by lawyers. So the accused is going to stand before court and is going to is the one who is going to cross-examine the witnesses and is the one who is going to do the work of a lawyer on his behalf. So that is on himself. So that is what, this is the critical moment, and this is the critical issue when it comes to jurisdiction in a court. So when the witnesses comes before court, they begin to testify before court. The first thing that the accused must do, he must be composed. So you as a paralegal counselor, you should encourage the witness to be composed, and you should tell the witness that the court is there to help that person out of the situation. So you have to give confidence to the accused that the court is not there to judge wrongly, but it's there to give justice to what transpired, and the court is there to hear from this accused. So the court is a neutral place. So that is the confidence that you should give the accused, so that they will stand in court in confidence, and they'll be able to know that I have got the court is there to hear from me. So that is the first process. Now, when the witnesses stand now before court and begin to testify, the accused must hear attentively to what the witnesses are saying. So there must be the listening skills from this accused. He has to listen to what the witnesses are testifying. Remember, the witnesses, they have got their lawyer, who is the prosecutor, who is going to guide them and guide them on what they are supposed to speak in court, and how they should what they should talk about in court. So you should bear in mind that the prosecution, they have got an objective, and the objective is to win the case. And they have to ensure that they convince the court that this client, your client who is the accused, committed a crime. And remember, you are not going to speak for the client, but you have to help this client speak for himself. You have to coach the client on how to do it, on how to speak before court, and be able to cross-examine the witnesses that the prosecution is going to bring. So there are 10 points that has to be remembered when cross-examining the witnesses, especially in the criminal jurisdiction. The first thing, as I said, you have to help your client, or you have to help the accused to be ready for the court. So he has to be composed, he has to be ready for court, he has to prepare for court. Number two, you have to teach your client not to answer questions from the person who is being cross-examined. Now, here is this accused is not the one giving the testimony, so he's not supposed to answer any question from the witnesses. So it is him to ask the questions. So he should not tolerate the answer. But when they ask the question, he has to be calm, and also to point out to the question that he's trying to ask the accused. or the witness. And when asking the question, they must be able to ask the leading questions. When we say the leading questions are the questions that are that contains the answer to the question. For example, you are the police officer, is it? When the accused was arrested, you interviewed him. And when you interviewed him, he told you that he was not there when that incident happened. So you are asking the leading question so that you may give the picture to the jury what really transpired. So now, in this case, it is the accused that is asking. So you teach your client to ask, when you arrested me, I told you this and this and this. Is it? And you did this to me, is it? So is giving the leading question. Then the fourth one is that insert only one new fact in a question. So when the cross-examining, don't bring a lot of facts in one sentence. Go step by step. Ask the question that is going to bring a fact. For example, as you are the police officer and you have been, for how long have you been a police officer? Then he's going to answer, maybe it's not necessary, or what I said, how long have you been a police officer? Then you say, have been a police officer for 5 years. How many days should an accused be brought before court? Then the police officer will say, no, it depends, and what. Then he asks, what does the Constitution of Zambia say that a person must be brought before court within 24 hours? Within 24 hours. Within 24 hours. Is that what you did? Then he's going to answer yes or no, or whatever. So you are cross-examining and asking point by point, leading to the conclusion which is objective, that you what the prosecution is doing or what the witnesses are saying are not even connected to the crime, and you did not commit that crime. So you break cross-examination into logical progressions towards specific goal, and the goal is that the crime was not committed and you did not commit a crime. You take control over the witness. So let not the witness control you. You have to take control over them, because you are the one that is asking questions. So you have to, they should not control you. You should control them. And when they begin to become emotional or what, you should be calm. One has to be calm and wait for them. Then you ask, I was asking, how long should one should a person be brought before court? Then you should listen to their answers, and it is from their answers where again you should develop another questions. Do not break down until the witness answers the question. So if the witness is trying to dodge from the questions, rephrase the question and also insist that the witness must answer the question that you have asked. So you should lead the witness to the conclusion that the testimony is not related to the matter. So whatever the witnesses that they bring, your purpose to cross-examine is to show the court that what the witnesses are bringing before court has nothing to do with the matter before court, and it is you as the accused or the accused did not commit a crime and did not do a wrong thing or did not the accusation is not tarring to what really transpired. So the last thing is to conclude. So as you cross-examine, there must be a conclusion to show the court that the incidents that happens and what the witness has witnessed before court is not valid, and the court should not take it as something that is true, or something that is agreeing with the matter and with the charge that is on the before court. Me taking peculiar advantage of their property or money. What are you telling the court? And when the transaction was made, there was something that we talked about, and we said that I'm going to deliver this service to you. Is it? And the time came when I was about to deliver the services, and there was a delayment, which I told you. Is it true? I'm asking. I told you that I explained to you why I'm not going to deliver the service at that particular time. Isn't? Now, are you aware that your products or your are on their way on work coming? Or I told you that the products will be delivered on the 5th of November. Did I? Is it true? Now, on 30th October, you reported me to the police. Isn't it? And I was arrested, and your products or your services was not delivered. Is it true? If I put it to you that I had no intention to take advantage of your money, and you obstructed me when I was ready to deliver the product, what would you say to the court? So when you look at that, you are giving the leading question to your client. Then the other thing that the other critical person that comes in, it is the arresting officer. So the arresting officer, who is the detective or the investigating officer, he will be able to come before court to summarize what the witnesses and to produce the evidence before court. So now he is a critical person that needs to be cross-examined. As I said, that these police officers will cook up the things, because they would want to cook up the evidence. So now it is your advantage if they do that. So the detective or the investigating officer is going to give witness on how investigated the matter. So now the duty of the accused is to destroy the credibility of the witness. So it doesn't matter how long and how experienced this officer is. The first question should ask the police officer is, you are the police officer, isn't it? You will definitely answer yes. For how long have you been a police officer? Then he's going to answer yes. Maybe 9 years or. So what is the duty of the police officers? Or the duty of the police officers is to protect the citizens, isn't it? And you said for you have been a police officer for 9 years. How many cases have you investigated for that period? No, that is none of the business. I'm saying that how many cases have you, can you approximate the number of cases that you have investigated? You may say 400 or what. And when you arrested me, I told you I did not steal or I did not beat this person, isn't it? But you went ahead and put me in custody, isn't it? After putting me in the custody, while I was complaining of the wounds that I was I was nursing because of the fight that we had with this person. Did I tell you about that? You said no. I requested for the police report or for the medical report. Why did you not give me? You answer, no, you didn't ask. But you saw, officer, you saw that I had some wounds and I needed medical attention. Was it so? You answer that. But why did you give the other one, who is the witness, the medical report, and refused to give me, yet you had to put me in custody so that I may not have opportunity to go to the hospital? So the officer is going to answer. Then you said you have been practicing. You have been a police officer for 9 years. Do you think what you did was right according to the duties and your what you have been commissioned as a police officer? So in doing that, you are destroying the credibility of the witness. So immediately when the what the court would want to hear the that what the witnesses are testifying are not the right things to do. So that is basically what your duty is as the accused. So the accused must stand in court and show to the court that the witnesses' credibility, or the witnesses, what they have testified in court, they are not credible, and they have cooked up those stories, or the stories that they are talking about in court has nothing to do with a case before court. So today, that is where we end, and God bless you. I want to believe that you are becoming great paralegal counselors to help those people that have no access to lawyers. Thank you so much, and God bless you.